Surviving the Survivor. Glad to see STS Nation in full force. As we all know by now, it is day 3 of the Alex Murdaugh trial, where a once well-respected attorney from South Carolina's Low Country, whose father, grandfather, and great-grandfather were all prosecutors in Colleton County, South Carolina. Murdaugh is now on trial for the murder of his wife and son, and that is just a fraction of the story. Our best guest tonight, here to break it all down, the man in the suit and tie with the pocket square making us all look cheap, is criminal defense attorney John T. Mobley. He is a native of Columbia, South Carolina. I know some of you said you better bring in some South Carolinians, and here he is. He earned his Juris Doctorate degree, otherwise known as a law degree, from the University of South Carolina, and has been in private practice for more than 25 years. The other gentleman is Alan Tuerkheimer. He is a Principal Litigation Consultant at Trial Methods. They help facilitate focus groups, moderate deliberations, and tailor jury research methodologies to properly fit the trial team's objectives. So we are glad to have both of you here. A couple of quick housekeeping notes. As you know, please follow us on Instagram, Facebook, Twitter. We're at Podcast STS. Support my dear mother at Patreon. Also, you can get a YouTube subscription directly. Without further ado, we've got a lawyer, we've got a jury consultant. Start sending those comments in. To you first, actually, John. Buster Murdaugh showed up today for the first time at court. We haven't seen him previously. Has got to be, from just a human, interest standpoint, a super difficult day for him. You're on the ground there in South Carolina. Any indication one way or the other how the family is dealing with all this?
No, not at all. And I know pretty much all the players involved in this case. I've been in front of this judge on numerous occasions. I used to work for Dick Harpootlian when he was solicitor and I was a prosecutor. I know Jim and played golf with his law partner. I even had a case with Alex briefly as co-counsel in a medical malpractice case a long time ago. But, as you can imagine, this is one that they're all being a little bit tight-lipped about. There are just too many things that can go wrong when they start sharing thoughts, ideas, emotions, feelings without those, with people outside the very close inner circle. So no real insight from an objective standpoint as how the family's dealing with it. I can speculate, of course, that everybody's got to be torn because on one hand, I'm certain that someone like Buster wants to believe his father when he says, he didn't do it. And he's lost his mother and lost his brother. And of course, he's seeing the news. He's seeing all the horrible things his father's not just been accused of doing, but admitted doing. But, so it's got to be hard for him to be there in some respect to show support for his father. But it's one of these circumstances where, there's just too much. The stakes are just too high. He has to do it.
And Janine commenting right away, Buster didn't look good. I caught a glimpse of him. He looks a bit shell-shocked, and I think that's probably what you'd expect as a young guy dealing with so much right now. Before we get to Alan, and obviously the jury was seated today, and there were opening statements. That is the headline, of course, which we're going to get to in detail. But prior to that, just John, to you, is this the trial of the century in South Carolina? I mean, what is the feeling on the ground when you're up and around? Are people everywhere talking about this trial?
Oh, no doubt about it. Here in South Carolina, this trial has all the feel of a heavyweight title fight with everything going on. Murdaugh, as everyone has known, is a well-known attorney. His lawyers are well-known in this case. It's brought a lot of attention to this state. Colleton County is a small town, so there's definitely no doubt about it. It has that kind of impact on the community. I mean, everybody's watching this one, all over the place. Everybody's commented on this case. Everybody's got opinions on this case. And I think one of the things really added to the mystery is normally when a person's accused of a murder or a high-profile crime of this nature, the prosecution normally lets the public know about the evidence. Normally, they'll lay out the evidence in the case, what ties the person to the crime. And in this case, the prosecutors didn't do that at all. They didn't really outline their evidence. I mean, they were very, very tight-lipped. They didn't go into any real detail about what evidence they had that tied them to the crime. So it really has a lot of people wondering, how strong the case is going to be.
And we got some information on that in opening statements, which we'll get to. But Alan, your expertise obviously is getting a jury seated. It's interesting. We've had two other jury consultants on the two previous nights. And what is stuck in my head is the first night, our jury consultant said, you don't want a fair jury. You want a jury that's going to, bring back a verdict on behalf of the client you're representing. It's sort of counterintuitive, but is that how you see seating a jury? You want the win.
You certainly want to advocate and do the best you can for your client, for who's paying the bill. But at the end of the day, if you think about it, if you have an idea of, you don't get to pick your jury. You don't get to say, I like this guy, or I really want this woman on my jury. Because if you, during the course of voir dire and the process of seating jurors, if it's revealed that there's a juror that you think is going to be really good for you, there's a good chance, unless it's subtle, that the other side will use a peremptory strike on that juror. So at the end of the day, you do tend to have people in the middle, because the people that are really pro-prosecution with that leaning will get kicked. People who are strongly pro-defense, they're going to get kicked. So then you have what are usually just people middle of the road who don't seem to go one way or the other. But yeah, each side is trying to get the best jury possible. And most of the time, when you seat a jury by kicking out the extremes, then you do get a fair and impartial jury that's going to look at the evidence and make an assessment based on what's presented in court.
And
John, go ahead.
And I think a lot of times when people talk about jury selection, you hear about the objective factors, this person's body language, all of the different general characteristics. But I can guarantee you, in a case like this, what these lawyers did is the same thing that I do in my murder trials and all my trials. They have the opportunity to get the jury list well in advance. And when I say the list, I mean they got a list of the entire pool of jurors that were going to be summoned to court for jury selection from that area. The smart thing to do, which is I'm certain these attorneys did it, I know they did it, just so we're clear, I know for a fact that they did it, is you get individuals from the community that you trust, that you know, that are involved in the community, and you have them go over the list with you. And they can give you additional insight. The jury list is going to give you the person's job, whether or not they're married, what they do for a living, where they live. But if you get people in the community, they're going to know the people on that list, and they're going to tell you what kind of people they are, what kind of prejudice they have, what kind of predispositions they have, which way they lean on certain issues, the things you're not going to get from just the generic things on a list. So that's how you pick your jury, because that kind of insight that you have are things that the prosecution's not going to have unless they do the same thing. Okay, so that's how you want to pick a jury in a case like this, and quite frankly, any case.
And John, what is the lead time on getting that list for both the state and the defense?
Oh gosh, at least a month or so. I mean, and it's very easy to get. The clerk's office of any county, they have that list and they can just give it to you. I mean, so they've had it for quite a while, and I can guarantee you they have gone over that entire list, gone over that pool with Murdaugh, with people in his family, with people that are not associated with the case, that just know people in the community, that have their pulse on the ground. That's how you get your jury.
So Brandy Sky won. I love the judge. We're getting a lot of contacts. And then BuzzFeed, who's back on here. Judge is a silent eye contact ninja. John, you said that you've had cases before this judge. What kind of person is he?
Yeah, I've been in front of Judge Newman on numerous occasions over the years. And he is that stone, steely demeanor the entire time. A lot of times when you're in front of judges, you can get a feel for whether or not they're with you or whether or not they're against you, or whether or not they're agreeing with the points that you're making. And I can tell you, just on experience, I'll be in front of Judge Newman making my argument, and he's just standing there and just sitting there, not making any expressions. And I think, hey, this man is really understanding my point. I think he's on my side, and he'll sit there and just stone face say, deny your motion. This is what I'm going to do. I mean, he's so unpredictable. But I will tell you, he's also a very no-nonsense judge. Judge Newman was an attorney in private practice for many years, a very successful attorney in private practice for many years before he went on the bench. And, he knows how to control his courtroom. He's very no-nonsense. He's not going to let it become a circus. He's not going to let lawyers get out of control. He will keep this courtroom and this trial running on a very tight ship.
And I understand that his daughter's a judge too, and he so far is sticking very much to schedule. Craftolitical writes, I'm surprised you can research potential jurors like that. Alan, you're probably not surprised because you're in this business. Is that kind of common practice to be able to research jurors ahead of time?
I talked to a lot of attorneys, and like John said, a lot of them consider it wrongdoing almost if you don't do that. It's expected as part of the process. And if you can get the list that far in advance, a month, like John says, that's wonderful. Sometimes the list comes on a Friday and you have a Monday jury selection. Sometimes it happens on the day of. So if you have the luxury to do that, absolutely. You do Google searches, look at LinkedIn profiles, Facebook, everything, just to see what the imprint is and what people are saying. And there's actually firms that you could hire to do that too. But I find it interesting that in this venue, it's smaller, that the list is so finite and limited that you can just talk to the parties and say, hey, talk to people in the neighborhood, and they'll know people on the list. It's very different than picking a jury in a big city. And I was curious too, at some point, I want to hear John's perspective on the judge and how he's doing voir dire, because most of the time my experience is in state court, the lawyers get to ask questions, and I haven't seen anything reported on how this voir dire has gone, except for the parties maybe were able to submit questions to Judge Newman for Judge Newman to ask. Do you think he's doing it any differently, or is this how he normally does it? And maybe this is how it is in South Carolina in a criminal case.
Yeah, in South Carolina, this is how it is. I mean, voir dire, although the judge has discretion to allow the attorneys to ask questions, voir dire is primarily conducted by the judge. What typically happens is both sides will submit prospective questions the judge would like the panel asked during jury selection, and the judge will decide what questions he's going to ask. And so, yeah, you rarely ever get attorney involved or conducted voir dire in South Carolina.
And John, to this question here from Betty Ross, like Betty Ross, but with the S in front, were potential jurors given surveys before reporting for jury duty? Do you know if that's generally the case, or you're just given the names?
No, I mean, they have to complete information, just background information to kind of make sure they're qualified. Make sure if you're under the age of 65. And just to be clear, certain things don't prohibit you from serving. There's certain things that allow you the option, like your age. There's certain things that are required. You can't be a convicted felon. There are also if you know anything about the case in relation to the parties, there may be people that are self-employed, that it's a hardship on them to serve on a jury, and there are things like that they ask to kind of pre-qualify a panel. You're a resident of the state of South Carolina, you live in the county, you can read and write the English language. Those are standard questions that the panel has to be qualified for prior to selection.
And so this particular case, there was agreed upon ahead of time a more extensive jury questionnaire that was filled out. This wasn't just what John was talking about with jury eligible, but this actually got into people's experiences with crime shows, alliances with law enforcement, and asked, a lot of lawyers love this question, what kind of bumper stickers do you have on your car? So there was a pretty, I don't know if it was 10, 11, 12 pages, but these jurors, before they showed up, I think before they were eligible to be quote unquote jury qualified, they also had to fill out questions that got at a lot of their attitudes and beliefs and backgrounds.
But is that typically, questions like that are fairly standard in voir dire, even in cases like DUIs. I mean, whether or not a juror contributes to for example, a group that has a primary, purpose of advancing law enforcement, mothers against drunk driving, students against drunk driving, citizens against violence, whether or not you're affiliated with law enforcement. Those are, the standard that the judge is going to ask in just about any case.
Alan, what is the most common question asked of potential jurors, besides what kind of bumper sticker you have?
A lot of times lawyers like to get at a political affiliation because it is true and it isn't true. It depends on the case, but I think a lot of times you can't ask it specifically in most courts, but I think a lot of questions are designed to get a sense of a juror's political persuasion because, and again, I don't think it's as applicable as it would have been maybe 10 years ago, but a lot of questions are geared to determine whether or not somebody leans left or leans right on the political spectrum.
And John, you're very used to this because you practice in South Carolina. Alan doesn't do all his work in South Carolina because he's based in Chicago. But Alan, how do you think it complicates things, in terms of the judge only being able to speak to the jurors and not, the state or the defense? Does it make things tougher for both sides?
I think it makes things more efficient. And I understand that this judge doesn't want to, I think circus was the word used. He doesn't want to have a circus. I'm not saying the lawyers, it doesn't sound like these lawyers would have turned it into a circus, but I'm a believer in the attorneys asking questions. I think when you do voir dire, you want to ask as few questions as possible and get the jurors talking way more. I usually tell lawyers that they should be, in voir dire, they should be talking for 25% of the time and listening for 75% of the time. And so I think if lawyers get to ask questions, I think they do a better job of asking the right questions because they're really thinking about what's best for their client. And the way they ask questions is so important to get jurors comfortable talking. You get jurors showing up in public, and sometimes the jury selection process is one by one. Other times you get a whole group of people at once being asked questions. Just because of the social pressure, candid information isn't always revealed when questions are being asked. Now, I'm not saying jurors don't tell the judge the truth, but I think the scope of the questioning is usually much more limited when a judge does it, for better or for worse. And so I'm an advocate of trying to get lawyers to ask the questions because I think you can get much more useful information to get insights into how a jury is going to view your case and your client.
Fair point, but just not the way it's done in South Carolina. I love this next comment. Don't know if I love the name, Gorgeous Junk. I never understood how some murder trials last a few days and others last weeks. John, what is the answer to that mysterious question? Because sometimes you see these murder cases go on, for what seems like an eternity. I just remember watching the O.J. Simpson case for one, and I felt like it lasted for like a semester or more. I was brief, just out of college back then. But what is the answer? Why do some cases take so long? Others seem to be done in a matter of days, if not weeks.
I think it's a combination of three different things. One, the complexity of the case. Two, the prosecutors, and three, the judge. Using O.J. Simpson for an example, that was a trial that I followed very closely. And the judge in that case, Judge Lance Ito, he just had zero control of anything. Mm-hmm. He let the lawyers argue about anything, any issue that no matter how small, he would let them have a 2-day hearing and call outside witnesses and then decide whether or not he wanted to rule on it. And it was just out of control. Also, I think sometimes prosecutors, some prosecutors can tend to overtry cases. I'm a big believer in keeping it simple. I just think that even the most intelligent, juror that's going to pay attention, you can only keep their attention and their focus for so long on so many different things. The more complicated the presentation is, the more jurors got to retain, which means they're going to forget certain things, and the impact of the strength of your case is lost in everything else. I mean, there's a saying I have about certain prosecutors. If a witness asks, what time it is, they'll put up a presentation about how to build a clock, which is not necessary. I'm a big believer in keeping things simple because people can follow it better that way. But oftentimes, we lawyers are the worst about keeping things simple. We tend to make things overcomplicated. We want to give people too much information. We like to hear ourselves talk. And I think that can tend to make trials last longer sometimes. And I think the best prosecutors, the best lawyers are the ones that kind of pare down their case and keep it concise and somewhat simple and easy to follow.
You just described my old career, TV news, where we all like to hear ourselves talk. Alan, back to you here. So there were 700 summons to find these 12 jurors and 6 alternates. More than 200 people were brought in for a first round of questioning. That lasted nearly 3 hours. Only 30 were qualified for the pool of potential jurors. And then we finally had our jury seated today. 8 female, 4 male. The alternates, 2 are female, 4 are male. What else, if anything, do you know about the makeup, and what do you make of all this?
I don't know anything else. I'm glad you reported that. I only saw that it was the 12 were seated with some alternates, and I'm not so sure this is a case that's going to break down along gender lines. I don't think it's going to. I don't think race is going to affect it. I'm not sure age will or education. I don't see it. That doesn't jump out at me. Certainly, people's experiences that they bring with them, their everyday life experiences, will affect how they assess the case. So it'll be interesting to see and get to know more about the jurors. Sometimes as the trial goes on, you do get to learn more about their backgrounds and their different walks of life. But it was a pretty daunting task. And again, I think with the judge doing the questioning, I think it was much more efficient and streamlined to get these jurors, because if you had attorneys asking questions, again, for better or for worse, depends on who you ask, but if you had lawyers asking the questions, this probably would have taken a lot longer. I'm betting that this judge asked very pointed questions about, what do you know about the case? Have you made up your mind? Do you feel strongly about it? And then judges are usually satisfied when they look at a juror, a prospective juror, in the eyes and say, can you set aside whatever you know about this case and be fair and impartial? And if the answer is yes, then that juror is probably qualified, which is probably why they were able to qualify so many jurors in such a short amount of time. Because if you think about it, the county is, I think, just south of 40,000, and Walterboro is around 5,000, maybe a little bit more. So you would, and as everybody's been talking about, this is a case that everybody knows is family. And I think one of the dismissed jurors even said that they were at a cocktail party or an engagement party at one of the Murdaugh's house, maybe his house, and this juror was struck. But everybody knows this family. Everybody knows about the case. So I think the judge just decided, you know what, we're going to try this case here. And I don't think there were objections with the prosecutors or the defense. They just decided we're going to get right to it. And if I don't see anybody with a bias in either direction, that they're jury qualified. And at the end of the day, that's what they did. Now we have 12 jurors and some alternates.
Yesterday we had on a woman named Amy Lawrence Lovely. I don't know if you know her, John. She's out of Myrtle Beach, defense attorney. She says when she's looking for a juror, she loves to have an engineer, I guess, because they're a little bit more dry, she says, and they follow instructions. Is there any specific type of person that you look for on a jury, John?
No, I mean, every case is different. I think the general things about a case, you're gonna want witnesses, jurors that identify either with your defense based on their personal experiences, or maybe you have some critical witnesses. Hey, if my critical witness is a truck driver, I want truck drivers on my jury because they're going to identify with the guy. So it's a case-by-case basis. There's no profile. I tell you, in a case like this, I agree about what you said earlier. You never want an impartial jury. I kind of think in a case like this, I want people that know about the case. The people that I want on my jury in this case are people that follow. I want the armchair detective. I want the person that's following all the podcasts and going down the rabbit hole of conspiracy theories on YouTube and the internet about this case, because that juror is going to have ideas and have read about things that are probably not true and are not accurate, but they're going to have these preconceived ideas and think, hey, the prosecution doesn't know about this, or there's some fact out there that they didn't tell us about that they still hold on to. And I think those types of jurors will hold on to that information. They'll think they've got some special knowledge, some special insight based on something they heard on a podcast or something they saw on the internet, and they'll use that to acquit.
That's super interesting. I mean, Alan, to you, is it becoming, I don't want to say a problem, but obviously true crime has blown up as a genre, and I don't think it's going anywhere because unfortunately we live in a violent country with a lot of crime, where a lot of crime takes place, which keeps people like John Mobley and now me employed. But do they ask now, are you a true crime fan? Because it is interesting what John is saying. There are a lot of rabbit holes on YouTube. We were covering, the 4 college students in Idaho who were savagely murdered. And the things that I found are, for lack of a better word, just wild. And they can definitely sow seeds of doubt. So I'm just wondering, Alan, from your perspective, are defense attorneys asking that question, or judges, or whoever it may be, are you a true crime fan? Is that coming up now?
Yeah, it's also known as a CSI effect. And I think that would be a really good juror for the defense, because this is somebody, and this was asked in the questionnaire, who watches these shows, who knows a lot about these true crime shows and all the spinoffs, because this is the kind of person who watches these shows and sees how cases are solved, which is very different on TV than it is in reality. They expect, quote unquote, a smoking gun. And in this case, literally, there's no smoking gun, really. I mean, I don't think the weapons were recovered, the rifle and the shotgun, or either way, there was no eyewitness. And so whatever it is, this type of person has a much higher threshold and holds the prosecutors to, if not the verdict, it's something higher, because they expect a smoking gun, or they expect that you can go into a crime scene and take certain evidence and conclusively determine what happened, when even though we have modern day technology that can solve crimes, it just doesn't compute or add up to what this juror has in his or her mind based on what they've seen on TV. So yeah, I think this type of juror usually helps the defense, because they have unrealistic expectations. And if it's harder for them to connect the dots and convict on circumstantial evidence, because what they've seen suggests that they should be getting something much more definitive.
And John, we're going to get back to you in a moment here, but some of the jurors today were excused because of their anxiety. One person saying they had PTSD, saying it's a very real thing, going through a trial of this tragedy with photographs, which will no doubt inevitably be offered, could be harrowing. There is a heightened sense of anxiety in the nation, I think, since the pandemic. Is that something you hear often from jurors who say, I just simply can't serve on this because I suffer from too much anxiety?
I've never actually had that one. I mean, I have to, but I have never had that one. And ultimately, I mean, one of the standard questions, is there any reason, you feel like you can't serve or you can't be fair and impartial? And if your reason is anxiety, hey, that gets you off the jury panel. I mean, it is what it is from that standpoint. I mean, I can certainly see how, if you live in that town, there will be some anxiety over serving, because although the jurors are supposed to be confidential, I mean, it's a small town. It's going to get out who served in the jury, and what can happen is, if you make a decision that's not deemed as popular, you worry about backlash. Particularly in a very, very small town. I mean, that is a realistic concern for someone in that small town versus a large major metropolitan area. So although I've not had that experience, I can see that it's a real possibility in this case.
And Alan, last question regarding the jury, and then we'll get into the meat and potatoes of the opening statements. But when you're dealing with such high stakes as a murder trial, does the dynamic or your job change at all in terms of being a jury strategist?
Yeah, you have to look out for, and this is not a hard case to get booted from. If somebody didn't want to be booted, it wouldn't take much to get kicked off this jury. But yes, you have to look out for a stealth juror. You have to look out for that juror who wants to get onto the jury to influence it with a predetermined outcome without regard to the evidence. So you might have somebody that wants to stick it to the Murdaugh family and who's thinking, I'm going to just answer my questions very neutrally. I'm not going to really tip my hat. I'm just going to try to fly under the radar. That person has an agenda. Or on the flip side, you might have somebody who wants to fight for an acquittal for this guy and his family for whatever reason. So yeah, you definitely have to have an extra layer of concern and vigilance for somebody who's purposely trying to make it on the jury. And I think just about everybody, certainly the judge, but the parties don't want somebody who seems overeager. And so it makes this juror so difficult to identify, is that they answer questions in a way that wouldn't tip people off to see that they want to get on the jury. But that's definitely something to look for in a case like this. A juror might want to be on because they think that after this case, even if they don't have an agenda in terms of innocence or guilt. They might think, oh, I'm going to write a book deal after this, or I'm going to be famous, or I'm going to blog or tweet. So yes, this is different than your standard case, even a murder case with so much on the line.
And I can tell you from a personal experience, I've tried several high profile cases in small towns where my client was well known by everybody, and they're very polarizing cases. And in situations like this, it's really the attorney's job to be extra vigilant when you're looking at the responses that you're getting from the jury panel. I mean, and based on a real life example for a case I tried, there are basic questions being asked by the judge about whether or not people had heard about the case, things along those lines, and people weren't standing up. And it was crazy that this was a big case in this town. It was all over the news for a long time. It was a very unique homicide case that, and people weren't even raising their hands saying they heard about the case, but it was my job as the attorney for the defendant to say, hey, Your Honor, that doesn't make any sense whatsoever. It's crazy for these individuals to say they don't, to not admit they've heard about the case, or there were witnesses that the prosecutor identified that, for example, worked for the fire department. And you had jurors that worked for the fire department, but didn't stand up and acknowledge they knew a witness that worked at the fire department. So in that particular case, I brought those inconsistencies to the trial judge. And we actually did individual voir dire. And what I found amazing is, it's something you alluded to earlier, jurors are often loath and apprehensive about making announcements or revealing things about themselves to a room full of strangers. If you've been a victim of violent crime, let's say you're defending someone who's accused of sexual assault. Well, obviously one of the questions is going to be, are you the victim of a violent crime? Have you, been involved in any kind of sexual assault? Well, who wants to stand up and say, yeah, I got sexually assaulted. Yeah, I was a victim of violent crime. What I typically do to try to ward that off is I will tell the judge, or ask the judge rather, because they can't tell a judge anything. There will be a certain set of questions that I think are going to be sensitive to jurors. And I will ask the judge to advise the jurors, if they have a positive response to these questions, to not say anything, just raise their hand and we were going to, bring them up to the bench or to the courtroom, jury room, and talk to them individually so they can be more comfortable discussing their circumstances. Because when you do that, you find out all kinds of things that nobody wants to stand up and admit to or announce in front of a room full of strangers. So, so if you can do individual voir dire on certain aspects of the case, it's extremely beneficial.
And we are going to slide into the opening statement section, but quick comment here from B. Young. The defense attorney seems very compelling. That's Dick Harpootlian. This is going to be a dogfight. You said you work for him, John. What kind of person is he?
Yeah, Dick is no doubt about it, whether you love him or hate him. Dick is the Cadillac of attorneys. 20-something years ago, when I was a young attorney just graduating from law school, Dick Harpootlian was the district attorney or solicitor, it's called in South Carolina, and he hired me, and I worked under him for a number of years. I have very vivid memories of being chewed out by him as a young, brash attorney. But hey, but there's no doubt he's the real deal when it comes to lawyers. I mean, he's extremely intelligent. He's well connected. He's a state senator. He's got a lot of connections. He's a great criminal defense lawyer. He's a smart personal injury lawyer. He's very, very comfortable in the courtroom. He's got a big personality. He likes a big stage. He is a great choice for a lead trial attorney in this case. There's no doubt about it.
It seems a little contradictory to me to have a state senator representing you on a double murder charge, but what do I know? This is an interesting comment. Gemma Gitter writes, and Alan, this one is to you, and then I promise we're getting to the opening statements. Where is the ethical line between a jury of your peers and a jury that is put together by capitalism in a bespoke way based upon how much money you are able to spend? It's a fair question, I think. Some people have the funds to hire guys like John Mobley. Others are getting your garden variety defense attorney and might not have the money to do what they need to do to get things done.
Yeah, that's how I would have answered the question, which I think I understood. It's a good question. It's a fair question, and I guess it depends on different people's point of view and where their ethics lie. But there's certainly, we know, advantages built into the system for those who are well connected, those who have funds and the means to access higher powered lawyers, and so everything kind of flows from there once you have that. Compared to, and there's certainly wonderful public defenders out there, but yeah, I mean, there's no question that influences the system, and a lot of people question the ethics of the system that allows for that.
So, as promised, before we even get to opening statements, Alan, did you have a chance to watch them by any chance?
Yeah,
I'd love your take, because we're going to dip into that and away from the jury stuff for now. John, to you, did anything jump out at you? Your old employer, Dick Harpootlian, had some mixed reviews today, which I'm going to get into. But what jumped out to you, since you are the criminal defense attorney, about these opening statements? Did one side or another have the advantage?
No, what jumped out to me were a couple different things. I mean, one, of course, for the first time you heard the prosecution lay out some of the details which they believe connect Murdaugh to the murder. I think from the standpoint of presentation of key facts, both lawyers did a good job of that. Where I think they could have improved, which why I would understand the mixed reviews, is they both went on for a long time, which is not in itself a problem. But when you have a very, very long opening statement and you're talking about so many different aspects of the case, you know, you're going to lose jurors because they can't follow all that. They can't retain all that. And honestly, I think they both would have benefited from the use of some visual aids. You know, even something that just, I think it's, again, keep it simple. You want to hit your key points. You know, you're going to have 4 or 5 strong things that are going to be instrumental to your case or your defense. And you want the jury to, you know, focus on those things. But when you talk about 15, 20 different aspects of the case and all the different timelines and the phone evidence and the physical evidence and the scientific evidence, you know, and the different theories, I think it's just too much for people to process. And they don't focus on your key points. I think they both could have benefited from the use of some visual aids.
I think that's a great point. Lead prosecutor Creighton Waters went just over 30 minutes, which to me seems reasonable. But just to give you perspective, I was talking to a very successful TikTok influencer. I'm not in that world at all. But they told me that they have 8 edits in a second on a video on TikTok. So this new generation coming up, their attention span, I mean, 8 edits in a second is absolutely bananas. But I think you're right. 30 minutes now for any human being who's in this digital age is an eternity. But anyway, he spoke for 30 minutes, a little more. This is Creighton Waters. He talked about how, and by the way, hello to Mary Binney, who's watching us from Scotland. So she must have insomnia, but she also is one of the few people that does not think the pronunciation Alex Murdaugh is strange. I found out last night it is Scottish, the genesis of that pronunciation. So, but we learned today from the state that Alec Murdaugh called his wife Maggie twice after she had been killed while he was about 1/3 of a mile away. He said Maggie's phone locked for the last time at around 8:49 p.m. Alec Murdaugh's phone did not register much activity from about 8:09 to 9:02, but at 9:02 he called his wife. She doesn't answer, he says. Of course she doesn't answer. He calls Maggie again at 9:06. Remember, he's just 1/3 of a mile, and on they go. I mean, John, how important is it for the state to set up this timeline to show that, that he is, in their eyes, the state, in their eyes, guilty?
Well, you always got to show that the accused had the opportunity. And I do want to kind of go back and talk about the opening statement one more time.
Sure.
30 minutes is not a long time. I mean, I've gone well over that in opening and closing, but I think it has to do with presentation. I think if you're going to talk for 30, 40 minutes, you got to tell a story. Don't just bombard somebody with facts and details and information. Tell the story. This is a story about this, and this is why this happened, and this is how we can show you this happened. Jurors can wrap their minds around the story, but just being bombarded with facts and details for 30, 40 minutes is just not a good idea, in my opinion. Now, as far as, but again, they certainly need to demonstrate he had the opportunity to commit the crime. They have done that. I mean, the defense claims they filed technically notice of defensive alibi. I don't think their alibi is by any means ironclad. I wouldn't even call it an alibi. In my assessment, if you're going to present a defense of an alibi, I like to be able to tell the jury, hey, it's physically impossible for my client to be in two different places at the same time. That's an alibi. An alibi is if you believe what I'm saying and what I'm presenting, you've got to find him not guilty because he could not have been there. What the defense presented was a timeline to account for his whereabouts for about a 30-minute period after the murders took place, but they could not account for his whereabouts, for that 30-minute window where the murder, could have taken place. I mean, so it's not a great alibi. I wouldn't even call it an alibi. I call it a timeline, but not an alibi. So I think that, the prosecution they're safe from that standpoint because, the defense can't say, they cannot disprove or demonstrate rather that he was not at that location at the time of the murder for that 30-minute window.
And Alan, Marie Hernandez is excited. Chicago is her hometown too, so you've got company. Back to Brandy Sky. I don't like to double up on comments, and I didn't even realize it, but they write, the jury has been warned, Alan, this is for you, by both sides of the hard evidence that will be presented. How can a juror prepare, recover from what is ahead of them? How difficult is that for, a member of the jury panel to see really graphic images? We know that the son's head was shot and it's very gruesome. How tough is that?
Yeah, it depends on the person and different people's sensitivities, but nobody wants to see that. And the lawyers are doing their jobs. They have to do that because if you're not forewarned and all of a sudden you see these graphic images, you're going to be repulsed, and you're going to probably use it against the lawyers before you make a judgment on the importance of that evidence and where it leads. You're going to think that was insensitive, either no matter what side of it you're on. It's always good to forewarn jurors when they're going to see something so graphic, and they heard a lot of graphic information during the opening statement. So I think priming them helps to a certain extent, but it's different when they actually get to see it. So there'll probably be some gasps in the courtroom when those photos of the scene first emerge.
And just going back to what John was saying, I concur 100%. In TV news, when I was a network news correspondent, a typical or an average news story is a minute and 30 seconds. And even that can start to feel long. So to John's point, I think that you do have to tell a story. You can't just sit there and throw up numbers and facts. It's going to lose itself on a jury of 12 peers. Back to this alibi, John. Creighton Waters went back to say that at 9:06 p.m., Alex Murdaugh then turned on his car and texted his wife that he was going to check on his mom before driving to Alameda, South Carolina, where his mother and her caretaker were. And then he drops this line saying, it's up to you to decide whether or not he's trying to manufacture an alibi. How important is the word choice on both the state side and the defense side? He says, you need to decide whether or not he's trying to manufacture an alibi. So there's already like an implicit prejudice in there that he's making something up, right?
Yeah, and I think I like the way Creighton put that out there, because that was my first thought, truth be told. Because I mean, we watch these, we read about it all the time in the news cases where the husband, kidnapped, killed the wife, and he just calls her cell phone over and over again to make it sound like he can't find her, doesn't know where she is. I mean, we see that all the time. That's not something new that people do when they kill somebody, and and I thought he made another excellent point about how how Murdaugh, when his wife was on the property and his son was on the property, how he's trying to call them and reach him and he can't do it, and he just leaves. He doesn't go try to find him by the dog kennel, or doesn't go try try to make sure they're okay, or just talk to somebody in person. He just sends a couple of random texts, doesn't get a response, and then takes off. And my first impression as well was that he's trying to develop an alibi so he can say, I was on the phone talking to all these different people. But I think it's great that the prosecutor didn't say conclusively that's what he was doing, because I think it's a big mistake to try to make assertions that you can't factually back up, but put that out there for the back of the jurors' minds, because I can guarantee you there are some people that were thinking the exact same thing.
And shout out to Lindsay Shea here, my favorite comment so far. Love how STS mixes the guests up, and they're all great. Very impressed, and I'm hooked to STS. We've got to get you addicted. Thank you for watching. We appreciate it. 2 phenomenal guests tonight. One of the bombshell revelations kind of coming out today in opening statements is this video. John and Alan, I'd love your take on this as well. Alex Murdaugh says he was never at the family's kennels. That's right near where the murders took place. Then went on to say that video evidence, this is Colleton Waters saying this, will prove that he was there that night. And there's been a lot of talk about this Snapchat video from Paul Murdaugh. And then Walters, the prosecutor, goes on to say that on the night of his death at 8:44:55 p.m., to be precise, Paul Murdaugh recorded a video from the kennels on his cell phone. It's now known as the dogtail video. He says Paul was down at the kennels because he had been talking to a friend of his, and you'll hear from this friend because his friend's dog was in the kennels, and they thought there was something wrong with the tail, and Paul was recording a video of it to send to his friend. And this is the part the prosecutor says that the state's evidence is going to show that on the video, the jury is going to be able to hear defendant Alex Murdaugh's voice along with his son and wife's voices. That puts him at the scene of the crime. How problematic is that, John?
I don't know how problematic that is. I mean, it's his home. It's not a big deal that he was there. If he denied being there in an initial interview, that's a very, very small statement that you have somebody who the defense would say, well, listen, this guy's son and wife just got brutally murdered. He's in shock. He's in grief. They immediately bombard him with these very aggressive accusatorial questions, asking about details that, quite frankly, in his mind may have not been that significant when you know, regarding what happened. So I think there's a strong argument for something like that when you have that detailed. I mean, you know, he can easily say, well, he forgot. He's at the house all day long. He's at the kennel. He's in the kitchen. It's 11,000 acres, you know. So him being at the kennel for 30 seconds or a minute would not be something that would be so significant that he would have to recall that detail, you know, perfectly every single time.
And Alan, John is smooth like butter, talking like a criminal defense attorney, and I'm believing every word he says. The problem with that is 3 minutes later, the phone locks up. And that is the comment that Colleton Waters adds. Just over 3 minutes later, after Paul Murdaugh recorded the video, his cell phone locks forever. Does that imply some sort of culpability that he's present so close to when these crimes allegedly happened?
That's I think really powerful evidence, and I guess there's different ways to spin it. But to what you were talking about earlier, when you do an opening statement, you need to tell a story, and that to me that would have been the cornerstone of my story from the prosecution about you can't trust him. Why can't you trust him? What are his motives? Here he tells in a statement, he says he's not there. Well, here's some evidence that shows no, he actually was there. Look at this video. So I thought that was a really big deal. I thought the prosecution, I think they're going to make a lot out of that. I'm not sure that his explanation is going to fly. He'll try as best he can, but I think that's a lot of heavy information that's going to help the prosecution. I would have emphasized that and re-emphasized that if I was the prosecution making an opening statement. When you talk to jurors after an opening statement, as we've discussed before, you want to have them understand what your case is in 2 or 3 sentences. And I think based on the scattershot approach from both sides, different jurors will say different things. So you really do want to be concise and focus your opening. I'm not sure they did it, but they offered so much there that it'll be interesting for people watching this trial and the jurors to see what direction they go. But I do think that that video sent by the son might come back to bite him.
And Alan, your take on today's opening statements in terms of which side edged out the win, if any?
I think maybe I'd give a slight nod to the prosecution. I just think that the way they did paint more of a story from a timeline than the defense. Now, again, maybe they did a little better, but of course the burden is on the prosecution. So if it ends up a tie, the defense wins. But I just think that the prosecution got out the narrative about what led up to everything and some of the strange things that are going to cause some questions in the minds of jurors about what he was doing and if he's being entirely truthful. And it's going to hinge on his credibility. I'm fascinated to learn whether or not ultimately, this is for another show, but whether or not he takes a stand in his own defense. It's so unique, this kind of case, where it is, what the charges are, but also representing a client accused of murder who's a lawyer. I mean, there's so many storylines here. And one of the citizens in that town, Walterboro, even said that. Someone asked what the fascination is, and he said, well, we know this family, there's powerful generations of prosecutors or solicitors, and he's a lawyer, and I just want to see how it shakes out.
John, any chance he takes a stand? Every defense attorney I've talked to said they would never let him up there.
Not in a million years. I think one, in general, I have a rule, that, and of course you talk to 10 different lawyers, you get 10 different answers, but I truly believe that, in a criminal trial, you don't put the defendant up unless you absolutely have to, because if you don't put the defendant up, the juror focuses on the strength or lack thereof of the prosecution's case. When you put the defendant on the witness stand, then his personality comes into play. Whether or not they like him, whether or not he seems like the kind of guy that might commit this crime, whether they thought he's been honest about this, whether or not he's arrogant, So you think about that, and then you add Murdaugh's inherent credibility challenges to the point of being not credible. I mean, the man is an admitted drug addict, prescription medication. He stole millions of dollars for people that trusted him with their lives, his clients, his law partners. He allegedly tried to commit some kind of fake suicide scam. I mean, how can anybody believe a single word this guy says? I mean, it's just like somebody giving you a bowl of spaghetti with cockroaches in it and saying, hey, pull all the cockroaches out, but eat the spaghetti that's left. No, it's not going to happen.
Dick Harpootlian. Let's say Alex Murdaugh approached Harpootlian behind closed doors and said, hey, I'm an attorney. I know what I'm doing. Let me on the stand. What would Dick's response be?
He would tell him to shut the hell up and sit down.
Have a bowl of spaghetti with insects.
Yeah, exactly. Gene Brown writes, and this one is to you, John, it can be dangerous to represent murder suspects. You can be in the fire line of unpopular clients. Have you ever found that? Because I hear that family court is way more dangerous.
Yeah, I've never found that in criminal cases. Criminal clients, even violent criminal clients, typically do not have any animosity toward their lawyers at all. It's just one of those things that might be great for a Lifetime movie or something like that, but in real life, that just typically doesn't happen. As you indicated, in the family court cases where you have somebody going through a divorce and fighting for custody of their children, you have a much higher chance of having that type of violent adverse reaction to a lawyer or to a judge. But in criminal cases, you just don't see that very often. I've never feared for my life from any, and I've represented some truly violent people in my career, and I've never felt any fear from any of them.
All your clients are innocent, though, right?
It helps that John's fit and big dude too. So there you go. There's quite a bit more to get through here. So the state went on to say that the weapon was a quote unquote a family weapon. That around Christmas 2016, Murdaugh bought two 300 blackout AR style rifles. You're talking to a Jewish kid that grew up in New Jersey, so I know about as much about guns as I do, rattlesnakes, which isn't a lot. One of these rifles went missing. And in 2018, he explains this, Creighton Waters does, that Murdaugh bought another rifle to replace the one that was lost, and says that Paul and his friends shot that weapon. The empty shells were found, but then the weapon, the replacement gun, there was a replacement gun purchased, but that replacement gun is nowhere to be found, according to Creighton Waters. Again, the implication there is that the gun was hidden, stashed away, and again, that there is some guilt associated with all of this. How strong a piece of evidence is that, in your opinion, John?
Well, I think it's kind of a double-edged sword, because at first blush, it sounds very damning that, and just so we're clear, they cannot match the specific shells ballistically to the weapon they found. Okay, they cannot match it to the weapon. It's definitely suspicious and troubling that specific round, though, even if they can't match it to the firearm, that the long gun that he had, it's definitely very damning that it was the exact same weapon or shell that was used in the murders, that he had that type of ammunition at his home. I mean, that very specific ammunition. I mean, that's something that is very concerning. But I think if I were defending the case, I would deal with that head on. I would use something I call legal judo, which is using what I call using the strength of the prosecution's case against him. The fact that they can't find the weapon, the fact that he had a very narrow window to commit the crime, because they can establish his whereabouts from around 9:06. Okay, so he had about a 30-minute window to not just commit the murders, but he had to have time to get rid of the gun and hide the gun. He had to have time to dispose of the bloody clothes. He would have been covered in blood. There's no way around that. Okay, I mean, those are very, very brutal, bloody murders. He'd have been covered with blood. He would have had time to get rid of the gun, wash himself, get rid of the clothes, and do it so well that there was no blood found inside the car.
And we're going to get to that, because that came up as exactly the argument that Dick Harpootlian made in the courtroom today. But there was some other damning evidence on the part of the state that they presented today. Creighton Waters again said that Alex Murdaugh brought with him a blue raincoat that he took upstairs when he went to his mother's or parents' home, and that when law enforcement searched the home, they found the raincoat wadded up, and it was coated with gunshot residue on the inside. So we're hearing about gunshot residue on the inside of that coat. Waters adding that the evidence would show that there was gunshot residue in a sink and on the seatbelt of the car that Murdaugh drove. Before we get to John on this, because I think I know what he's going to say, Alan, I'm curious to hear your thoughts on this evidence presented.
Yeah, I think it's more evidence. Now, is it direct evidence? I guess in a way, but I think that the prosecution is just going to use that and other pieces of forensic evidence, which the defense said there is no forensic evidence. The prosecution says there's a lot of forensic evidence, but sure. I mean, you want to cause jurors to think, well, what are the chances of that? Why did he bring that coat there? Why did it have the residue on it? Was he shooting? What are the chances he was shooting some other gun somewhere else? I mean, even he will say that he wasn't doing that. So yeah, I think that's just another piece of the puzzle that the prosecution is going to use to help get a conviction in this case.
And John, I don't want to put words in your mouth, but I'm about to do it because I'm practicing being a defense attorney. So if you were representing Alex Murdaugh, you're going to say South Carolina, it's a big hunting community. He likes to hunt. He could have been out hunting. That's why there's residue on his coat. Has nothing to do with these heinous crimes. Am I close?
You're very. I mean, and not South Carolina. I mean, they lived on hunting land. As you heard, they admitted they had a gun room. I mean, and if you know anybody that's a hunter, they're people that just they have guns. They have handguns. They have shotguns. They have rifles. They hunt. And when you hunt, you're going to have gunshot residue on your clothes. You're going to get in your car. They can't say that gunshot residue hadn't been there for 2 weeks or 5 days or 3 weeks, they would concede if he shoots guns and he hunts, or his son hunts, or his wife hunts, and they could get it in the car. What would be more compelling is the presence of gunshot residue on his hands. Because when you fire, if you're going to shoot a shotgun multiple times and in the same night shoot another long gun multiple times, I think 7 shots in total were fired. I can guarantee you he would be covered. His hands would be covered with gunshot residue. Now, you could argue he wore gloves, but then, now you got something else he's trying to get rid of in that 30 minutes. Now, in 30 minutes, he's trying to commit the murders. He's trying to get rid of the clothes. He's trying to clean himself up. He's trying to get rid of the gun. He's trying to get rid of the gloves. And he's done all that, and law enforcement, despite their best efforts, can't find it. I think that's where they have problems. I think that's where they have the problems in this case, because you're correct. If you are on a hunting land, you're going to have gunshot residue and shell casings all over the freaking place.
So that is a problem for the state. L. Collins writes, seriously, I feel Alex will get off on these particular charges. Part of the rub on this case is it's, bigger picture about corruption in this small county in South Carolina. I don't know. Do either of you guys care to weigh in on that comment? Is it too early? John, do you have a hunch one way or the other?
Well, I don't think it has anything to do with corruption. I think ultimately this is a case that can go either way. I don't think that and we're all intelligent individuals, but we haven't heard anything, I think, conclusive from either side that makes you think, something, that evidence is so strong, he clearly committed the murder, or that defense perspective is so strong, there's no way he could have done it. I think this is one, I would give an edge to the prosecution, but I wouldn't say they have, based on what I've seen thus far and what I've heard thus far, they haven't laid out what I would consider an overwhelming case. I think that's one factor. Another factor is, I think with the jurors in a case like this, there can be people that think that he did it. And whether or not the fact that they think he did it is enough if they're not satisfied by the evidence. I think most people think he committed the murders. But the question is, are they going to convict him because they think he did it, or because the evidence is strong enough? A la O.J. Simpson,
Yeah. Interesting point there. So on to the defense side now. We all know Dick Harpootlian is the lead counsel. Someone pointed out that during his opening statements, it started raining so hard you could barely hear him. So I'm wondering if that is an ominous message from a higher authority. Who knows? But Harpootlian came out of the gates, basically said to the jury, forget what they just heard from the prosecution during its opening statement, reiterating that his client is not guilty, that Murdaugh is accused of killing his wife and son, but that the burden is on the prosecution to prove guilt beyond a reasonable doubt, and then went on to use the famous words, Harpootlian did, he is presumed innocent, pointing at Murdaugh, and then dropped kind of the hammer, the mic drop moment for him. He says, he didn't do it. He didn't kill. He didn't butcher his son and wife. John, to you again, just sort of repeating this, that the burden is on the state. He didn't do it. He didn't do it. And then this very emphatic, he didn't butcher his wife and son. Again, to the point of choosing your words properly. He's, as my friend Steve Cohen says, don't put the emphasis on the wrong syllable. He's putting the emphasis on exactly the right syllables here, kind of really nailing the point home, right?
Well, I think a couple different things. And Dick's a great attorney, of course. And again, like you heard me say, you talk to different lawyers, you'll get different opinions. I personally, when I'm defending a criminal case, I don't like standing in front of a jury arguing burden of proof and presumption of innocence. I don't like doing that. When you start arguing, hey, they got to prove my guy guilty, I think you're going to have some people thinking, well, it sounds like you're saying he's guilty, but they can't prove it, and I don't like that. I prefer to tell a story, again, a story where I demonstrate a theory of defense by which, if you believe that, if the juror believes that, they will find my client not guilty. But I think they can wrap their minds around my story and my theory of the defense better, as opposed to me just, yelling reasonable doubt and presumption of innocence over and over. The judge is going to tell them all that. The prosecutor tells them that. They don't need to hear that from me. They need me to focus on my theory of defense. One thing too, as much as I respect Dick as an attorney, I think he could have been a little more respectful when he described what happened to the wife and the son. I mean, if I was sitting there, I wouldn't want my lawyers, talking about how my wife and my son got butchered. I think that's kind of borderline disrespectful. I mean, they got killed. I mean, they were killed violently. They died a horrible death. But I would kind of tone that language down just a little bit, just to show a little respect.
I'm glad you brought that up, because Harpootlian said that his head, meaning Paul Murdaugh's head, literally exploded from the gunshot wound, and talked about brain matter. And at that moment, Buster Murdaugh, who's Alec Murdaugh, actually broke down in tears. The defendant broke down in tears. I don't know. Did he do that maybe on purpose to try to get the emotional gain from that?
But you don't gain anything, because when the jurors are outraged. I mean, when you have a violent crime, jurors typically want to hold somebody responsible. When you have a violent, horrible, just brutal crime, they worry about letting that person go. So I don't think you gain anything from the defense by really going into graphic detail about how gruesome the crime was. Now, what I would have done, and I can understand saying, listen, I don't want to, unnecessarily go into details about the violent nature of this crime, but the experts are going to tell you, even the state experts are going to tell you that, and he did address this, which I think is a great point, was that, based on the distance by which, the victims were shot in this case, there's something called backsplash or backsplatter when the person's shot, and the shooter would have been covered with blood. Okay, that's a great point. But talking about those kind of details, I don't think you score any points with anybody. And I think you detract the graphic description and the graphic nature detracts what your real point is. Your real point is this is a violent shooting, and whoever killed these individuals would have been very close and would have been covered with blood in the backsplash. And then you say, well, you're going to hear they didn't find that kind of blood on Mr. Murdaugh. They didn't find it on his clothes. They didn't find, and he would have needed time to wash his hands. He would have needed time to dispose of all this stuff in 20 minutes. And, that's how you use that, in my opinion. But of course, I'm not up there in front of the jury, so he didn't hire me, he hired Dick. So,
would you have taken the case? I heard some people in South Carolina say there's no way I would touch this case.
Yeah, I mean, I think the only problem when you have a case like this, or the reality of it is, it kind of shuts your firm down. That I have a substantial practice, with clients around this state, and criminal cases, personal injury cases, catastrophic injury cases, and a case like this, I would have to bring a team in, so it just didn't monopolize my entire practice for a year. Because to try this case properly, you need to focus on this case and put everything else aside. So, but yes, I will take the case.
And he's got some money still stashed away. This next one comes from Renee Mason. And Al, we'll throw this one to you. And we not only have the best guests in all true crime, but the best fans, the best viewers, the best audience. Renee writes, I want to know what Alec Murdaugh was wearing in Paul's video and what he was wearing when he got to the mother's house. I think he had shorts and a T-shirt under the clothes he was wearing when he killed them. That raises a good point. It's something I didn't think about. But Alan, you're around the legal system enough. Do you think this is an interesting observation?
Yeah, I know enough to know when you don't know something, or at least what jurors are, what's on the minds of jurors. And this is why I do a lot of focus groups and mock trials and talking to jurors after cases, because you just don't know exactly what they're going to pinpoint as something that's significant. You might think that there's something in your case that should carry a lot of weight, and the juries think, oh, well, it didn't resonate with me. Equally common is similar to this comment, something you might overlook, and a juror will think, well, this is a question I have. Now, I don't know what the rules are in this judge's courtroom, but in a lot of cases, jurors get to ask questions. They get to write them down. They're vetted ahead of time, and the lawyers, and get together and then they come up with a way to answer. The judge has to accept it. It'd be interesting if that's going to happen in this case, because a lot of times jurors have just as many questions as they have answers to the evidence are presented.
And here's another interesting one for you, Alan, from Ray of Light. We've got some paranoid viewers, which I love. Please ask your experts how the public or state ensures that jurors aren't passed a note by a hotel maid that says $1 million offshore account to acquit. How do you know that you're keeping the integrity of the jury for the entire duration of the trial?
Yeah, see, this is what we talked about, watching what happens on the big screen or on TV. It's closely watched. I mean, I can't imagine a trial more closely guarded by the bailiffs, the judge, by everybody. And you know what? If something crazy happened like that, a juror would come up and say, "Hey, this is what happened." Judges admonish all the parties not to talk to jurors. They tell the jurors not to talk to the lawyers, even if you see them in the hallway. So, a lot of things we don't know about, but I can be pretty confident that that question is not going to become a reality in this case. But it's interesting to talk about because there's a lot of factors going on here in this trial.
There's so many moving parts, a lot of dead people that showed up. It's really a wild trial, and why it is being billed as the trial of the century in South Carolina. Back to Dick Harpootlian and the opening statements from the defense. He pointed out there was no forensic evidence such as fingerprints or blood tying Murdaugh to the murder. Again, he pointed to that mental framework. He talked to the jury and he said, your mental framework is he didn't do it. They have to prove it to me beyond a reasonable doubt. So again, he brought that up. And then the issue of blood. No blood was found on the clothes Alex Murdaugh wore that night, the defense attorney said. And goes on to say that investigators tested 12 different places on Murdaugh's shirt and pants and found no blood. And then he went on and talked about the issue, which we just discussed, about how violent these injuries were, and said that whoever shot Maggie and Paul were probably no more than 3 feet away. And exactly to John's point a little earlier, I think John almost said this verbatim. Harpootlian said whoever did it would be covered in blood from head to foot in blood. So, John, I mean, this is a tennis match. You know, one player's winning the rally, then the next player wins the next rally. But this is Harpootlian made some strong points here with the lack thereof of human blood as one of his talking points in the opening statements. Strong on his part?
Well, just to kind of clarify what he said in the reality, and I think it's a problem for the prosecution. In the initial test for the blood on the shirt, what they found blood, but it wasn't human. It was determined not to be human blood. Okay, and then at some point, the prosecutors involved in the case or the agency involved in the case decided to have another individual outside of the law enforcement agency conduct some additional tests, and then the opinion changed to be, splatter evidence of human blood, and that's a big problem. I mean, there was a big pretrial motion raised by the defense to suppress the blood evidence in this case. For that reason, the judge has not ruled on that yet, but it is a problem when you have one set of experts on the same side, law enforcement, that has a different opinion from another expert law enforcement hires, and then I think not only is it a problem regarding the reliability of the results of that testing, but then it opens the argument regarding the biasness in the investigation, that the prosecutors and law enforcement we're so fixated on trying to, make Murdaugh the guilty of the killings that when their expert didn't give them the opinion they wanted, they went and found somebody else to give them the opinion they wanted to time to the murder, which calls into question all the biasness involved in the investigation, which is a big part of the defense. that there are other suspects, that there are other leads, there's other, and these types of arguments are consistent in most criminal investigations, that the prosecutors and law enforcement in particular, more importantly, law enforcement, they will fixate on a particular suspect early on in an investigation. And what they'll do is they will follow the evidence that leads to him being the suspect, and they will ignore the evidence that's inconsistent with him committing the crime. And they'll just go down that path. And, so I think this supports that argument. So it's they got a double whammy, a double barrel argument on this one.
Yeah, and then the defense contends that the shirt was in fact destroyed before they could even get to testing it. So this really could be the X factor in this case, because if it's not admitted into evidence, that's a big problem for the state.
Yeah, and the shirt wasn't destroyed. They still physically have the shirt. But what happened is that the method of testing used the second time more or less made it impossible to be tested again independently for blood. So the defense's ability to have their own independent test of the shirt is gone now. So, but I will tell you that in South Carolina, and particularly in violent crimes, I mean, judges typically are loath to suppress evidence, and typically there's a catch-all, fail-safe where the judge can say, well, that goes to the weight of the evidence, meaning how strong it is, the strength of the evidence, as opposed to whether or not it's admissible, which means, hey, you think there's some problems with the evidence, you think the experts are not reliable, you think the testing results are not valid. Well, you can argue that in front of the jury, but I'm not going to not let the evidence in just because you want to attack it for not being strong.
Salt Phone, if my eyes are still holding up here, writes, the arrogance, and Alan, this one's for you, the arrogance of the family members sitting behind the accused, joking, laughing, shaking their head in disagreement to the prosecutor's words should be removed, clearly trying to get a mistrial. Your thoughts on that? Should it be allowed or no?
I shouldn't be allowed. I don't know if they're trying to get a mistrial, but it just goes to show, and this is what jurors do, they pay attention to everybody in the courtroom. So whether or not it's family members, whether or not it's a defendant, Alec himself, jurors are going to be watching. So, and I'm sure Alec knows this as a lawyer himself who's been in the courtroom, but he just has to remind himself that when someone else is talking, you just have to show respect. Don't shake your head. Don't show anything visible. Don't become upset, because the jurors are watching. And even if there's a witness on the stand or an attorney speaking, the jurors are going to be looking around and they're going to pick up things that aren't per se part of the trial or directly part of the trial, but those are factors that are important to them. So it's a good reminder that they're always watching.
And I hope John Mobley doesn't bring a criminal case against me, because I told him it was an hour and we're running a little long. We'll wrap in about 5 minutes or so. But Lindsay Busk writes here, the Snapchat video is very damning to the defense. The defense kept insinuating that Alex is not guilty because he's not covered in blood, like he couldn't have cleaned up in the hour before he called 911. What's interesting to me about this comment is people, John, already form their ideas in the court of public opinion, which is different than the courtroom. As a defense attorney, how do you check the court of public opinion, or do you just put your blinders on and move forward?
Yeah, I mean, I think there's nothing wrong with that. I mean, I think that, if you're a member of the public and you're reading news articles and you're watching the news and you want to form an opinion about what you think happened and discuss with your friends and your family, I think that's great. You're entitled to do that. That's your right to do that. But, when you serve on a jury, well, the rules say you're not going to do that. And you have to, concede to the court and to the lawyers that, hey, you're going to put all that aside and make a decision based on the evidence, So, but I just think that's just one of those things. That's just life. You got to deal with it as a lawyer, and it's your job in that courtroom to make sure that even if they have preconceived ideas, even if they have preconceived notions, you show them things and you explain things to them that they didn't think about before. That's going to make them think about things a little bit differently. So I got no problem with that. I'm up to the challenge.
I don't know if you, John, know Eric Bland. He's coming on our show tomorrow night. He's a criminal defense attorney out of the great state of South Carolina. He tweeted out, Defense focused on lack of witnesses, videos, fingerprints, blood, evidence, or anything. Positive that there were two shooters he could be, and Dick spent his time focusing on Alex's presumption of innocence right now. I guess he feels like Dick should have spent his energy focused on that other stuff, was instead talking about the presumption of innocence. You agree with this or no? If I'm reading it right.
Again, and I'm not friends with Eric, but I know Eric actually has, he represents some of the individuals in the civil suits that sued Alex Murdaugh. So, but I do agree that in an opening statement and in closing argument, as a defense attorney, I don't like standing in front of a jury arguing reasonable doubt and presumption of innocence, because I know how people think. They're going to think, oh, you're not saying you're not saying he didn't do it. You're saying that the state can't prove he didn't do it. So I'm a big believer in saying, hey, my client's not guilty. He's not guilty of this offense, and this is why he's not guilty. And I like to hit the facts, hit the themes, as opposed to the basic legal stuff that everybody's heard since, fifth grade social studies and civics about the presumption of innocence and the Constitution, blah, blah. That's not going to impress anybody. That's not going to get anybody's attention. I think you're wasting your breath, and you could be spending that precious time you have their attention on the main points you want them to remember.
And then, Alan, this is another tweet I found interesting today from Miss K, South Carolina. So you mean to tell me Alec Murdaugh, was at the house while someone killed his wife and son, which means he would have heard the series of shots, and then he tries to call his wife multiple times and she doesn't answer. So instead of going to check on her, he just leaves, presumably to go to his parents' house. That's something that the state is going to certainly latch onto if they're smart, right?
I agree 100%. I think that is problematic, because they would have had to have been killed in that very short window. And yeah, he would have heard the gunshots, and again, they're out there somewhere. I'm calling and texting. I can't get anybody. I mean, they can't be that far away. Why not just walk over to the camera and say, hey, babe, I'm going to visit my dad. I'm going to visit my mom. You want to come? Hey, son, let's go visit grandma. She hasn't seen us in a while. I mean, something. But you're at the same house with everybody, and you're texting and calling people, supposedly your wife or your son, and you're not reaching them, and you just leave.
Just another comment or two, and we'll get final thoughts and wrap it up. Alan, to you from Sharon M. Drug addict, fraudulent, but is he a murderer? I mean, the defense is really going to hone in on that. They're going to say, yeah, he's a criminal. Yeah, he's being brought up on 99 criminal charges. Yeah, he stole money. Yeah, he admitted to doing drugs, but that does not make you a killer. That's the old defense argument. Does it hold up with 12 reasonable jurors?
I think that's also why Harpootlian was being so graphic. I think he wants to get some of the jurors thinking, how on earth could somebody do this to their son and to their wife? Yeah, it's unpleasant. Nobody wants to hear it, but that's what happened. And there's some jurors and this is why the voir dire would have been so interesting to listen to. But there's probably some people on the jury that they're trying to reach that are thinking that this is just incomprehensible. How on earth could this happen? And they might fight for an acquittal. And using the law, jurors tend to keep an open mind. I do agree that you do want to have a story. You want to have alternative theories, but it works. I mean, look at the Casey Anthony case. The jury basically said afterwards they thought she did it, but the state didn't prove it beyond a reasonable doubt. So sometimes it works. Doesn't always work, but the defense has that going for them, and I don't think it hurts to reiterate it over and over, because in opening statements, that's the framework jurors are going to have as subsequent information and witnesses and evidence comes in. So if that's their mindset, I think that's something the defense has to do. And maybe it's indicative of they don't have a very strong case. And if they place Mr. Murdaugh at the scene of the crime, then he's probably in trouble.
Chico's mommy is a friend of the show. She comments frequently. She says, there is corruption. Just look at the body count surrounding them. It's hard not to agree with Chico's mommy on that one. But here, this one, John, we'll make this the last comment because I know you both have to get going. Wife and son killed. Do we know where the other son was, meaning Buster? Wonder if son was involved in Alec covering for him. Do we know where Buster Murdaugh was when this was all playing out?
I can tell you, I do not have that information. I am certain that I would assume rather that as part of their investigation, they would not just try to identify suspects, but eliminate suspects. So I cannot imagine that he was not questioned at some point during the investigation, and probably not just questioned, but probably polygraphed in this investigation. I've never seen anything indicate that he himself had an attorney at all during this case. So I'm reasonably certain that he was eliminated as a suspect. If he was not eliminated as a suspect, I am reasonably certain that the defense would have argued that the prosecution could not have ruled him out. I think that would be, honestly, a great argument because, it fits into the defense being they were so fixated on trying to make Alex Murdaugh a suspect because of all these other things that they ignored the evidence. This other person had the opportunity and the motive to commit the crime, and they didn't, investigate him as a suspect. So, but realistically, in a case like this, I'm certain that he had to have been eliminated as a suspect very early on.
The man who helps seat juries and does it in a very proper and professional manner is Alan Tuerkheimer. He's principal litigation consultant at Trial Methods. If you need a jury consultant, John, Trial Methods out of Chicago, a hop, skip, jump away. They facilitate focus groups, moderate deliberations, and tailor jury research. We had opening statements today, Alan, but what is your closing remark on this show? Do you have faith in the jury system, the 12 jurors who are seated, and will we see a fair outcome based on that?
Yeah, I think so. I think when jurors get the summons in the mail, usually they shrug and don't want any part of it and try to get off. I think this is, and of course, this is a high-profile case in a smaller town, a smaller area, but the jurors that I talk to after they serve, they invariably find it very rewarding. They're glad they did it, and they feel like they really contributed. And I think that's what's going to happen here. Of course, we have to expect the unexpected. There's certain things that have been reported that might tilt one way or the other in a court of law, but it'll be interesting. It'll be fun to watch. And yeah, I think at the end of the day, justice will be served because the jury is going to render a verdict based on the evidence and render their verdict the way they think is just.
The handsome man in the suit with the pocket squares, criminal defense attorney John T. Mobley, a native of Columbia, South Carolina, got his law degree from the University of South Carolina and has been in private practice doing criminal defense and other work for more than 25 years. John, your closing remarks, and what are you looking for in the coming days of this trial?
I'm not seeing a slam dunk on either side. I think that, when they start their presentation of evidence, they need to start scoring points on the board in this case. They need to pare it down and hammer on their strengths, because I think both sides have very, very strong points that you could use to justify either convicting him or actually finding him not guilty. I mean, it's not a slam dunk by any means. I would not be surprised if this is a hung jury or an acquittal.
Thank you so much. Thank you to STS Nation for all your awesome comments, which are still flowing in. And a big thank you, because we hit 2 million views for the last 28 days. And that is all because of you. Tell a friend about the show. We would appreciate it. Tomorrow, we are going to do another live episode on the Alec Murdaugh trial, but we're doing a second live show on Bryan Kohberger and what's going on right now in Idaho. There is some news to report there, and they're working me triple hard because in the morning, I'm doing a recorded interview with Dr. Henry Lee, the most famous forensic scientist in all the world. He worked on the JFK case, worked on the OJ trial. He's worked on them all. So if you have questions for Dr. Henry Lee, you better shoot him to me tonight, because I'm talking to him first thing in the morning. Thank you, everybody. Love you, America.
Good night.
Thanks a lot.